You're welcome to my channel. We are still continuing with business law. So in this video we are going to look at a sale contract distinguished from other types of contracts, or a contract of sale distinguished from other contracts. So other contracts that we have the contract for supply of services, we have the contract for bailment, we have the hire purchase contract, and then we have the contract for sale and barter. So we are going to be looking at each of them, and we are going to start with the contract for supply of services. So the contract for supply of services, according to section 3 subsection 1 of the Supply of Goods and Supply of Services Act, it defines a contract of supply of services, as you're hearing, supply of services, as a contract where a person agrees to carry out a service. So here there is an agreement to carry out a service but not to deliver goods or to transfer ownership of goods. So there is an agreement to carry out a service. So whether goods are transferred or to be transferred, bailed or to be bailed by way of hire under the contract, regardless of the nature of the consideration for which the service is to be carried out. So in the process of executing the contract, goods may be hired, bailed, and very many other things, but still the main aim of the contract is to carry out a service. For example, if you hire someone to decorate for you, you've hired a service provider, so they're supposed to provide a service, and that service is a decoration. Whether they hire those flowers, the chairs, the tables, like, that is not your main focus. Your main focus is the decoration, the service that you hired. Yes, so it is where a person agrees to carry out a service. So a contract for supply of services involves an agreement where one person agrees to carry out a service, even if goods are transferred, hired, or bailed. This is irrespective of the nature of the consideration for the service. So the focus of such contracts is on the use of someone's skill and labor to perform the service. Yeah, so that is the contract of service. So what is the legal distinction between the sale of goods and the supply of services? In sale of goods, the seller is strictly liable for any defects in the goods, even without negligence. So in the sale of goods, in case the seller sells something that is damaged or something that has a problem, they are liable, they are held accountable for that damage. Yeah, and this liability is governed by the Sale of Goods Act. Then in the contract for the supply of services, the supplier's duty is to exercise reasonable care and skill in delivering the service rather than being held strictly liable for any defects in the service provided. So for the supply of services, the supplier is supposed to be careful and then apply skills and professionalism when they are delivering the service that they were hired. For example, in the case of Lee versus Griffini, the client hired a solicitor to perform a service which included drafting legal documents. So even though the documents would become the client's property, the court ruled that this was a service contract and not a sale of goods, since the solicitor was hired to perform a service, though the service involved drafting legal documents. So even though the documents would belong to the client, that was not a contract of sale of goods, it was a contract of supply of services. Then we also have another case of Palmater versus Beth David Hospital. A patient received a blood transfusion from a hospital. The blood turned out to be contaminated, and the patient tried to argue that it was a sale of goods, so the hospital could be liable for the defect. So court ruled out that it was a service contract. with the blood being part of the service and it was not a sale. So all these cases show that in the sale of goods, the seller is liable for any defects in the goods. Then for the supply of services, like the seller is not liable for the defects in the service. They are instead supposed to exercise reasonable care and skill and professionalism when they are delivering that service. I hope you understand this. The exclusion of employment contracts from the SOGISA, or the Sale of Goods and Supply of Services Act. So Section 3, subsection 2 of the SOGISA specifies that the provision for the supply of services do not apply to employment contracts. So employment contracts are not included in this act. This means that the contract of employment, which typically involves services provided by an employee, is not governed by the same rules as contract for supply of services. So employment contracts are not under SOGISA. Yeah, so we have a case of Dodd versus Wilson in 1946, where a veterinarian vaccinated cattle using a vaccine he bought from a supplier. So court ruled that the veterinarian was responsible for the vaccine's quality even though he didn't sell the vaccine directly. The veterinarian was still liable because he promised that the vaccine would work for its intended purpose, but it didn't. So this case highlights that while the contract was primarily for services, there could still be implied warranties regarding the quality of the goods used in performing the service. If someone pays you to provide a service, you are supposed to make sure that you check the quality of the goods you're using to deliver that service. Yeah. So